So you were talking at the table about the fact of Jackson's portrait.
Yeah.
John brought up the question, or you had a great answer, and I wonder if you want to share that.
Yeah, of course. So in the Department of Justice, if you walk the halls on the 5th floor, what you see are the portraits of attorneys general hanging in the halls. But you won't see the portrait of any of the great attorneys general hanging in the halls, and there's a reason for that, and that's because the leadership of the Department of Justice has the ability to take the portraits that they want of attorneys general and hang them in their conference rooms. And Robert Jackson is one of those rare attorneys general who is revered by Republicans and Democrats alike. So his portrait always goes very quickly in the pecking order. And by the time you get to the SG, choosing portraits for the SG's office, you've already had the AG pick and the deputy and the associate, and the SG is fourth in line, so Jackson's portrait is never available. And for me, when I became SG, I would attend a daily early morning leadership meeting that the Attorney General, Eric Holder, had in his conference room. And I sat every day right across from the portrait of Robert Jackson, staring at the thing and wondering how I was going to be able to get that back to the SG's office where it rightfully belonged, because Jackson, of course, is the Attorney General who's also revered by everybody in the SG's office. Well, eventually I realized I was never going to pry it loose from the Attorney General, so what I did was I had a copy made of that portrait, and so now there is available always in the SG's office Robert Jackson's portrait. So that problem was solved.
You mentioned the fact that Jackson is revered by Republicans and Democrats alike. Why do you think that is?
Several reasons. He was, of course, a New Dealer. Robert Jackson, he was one of FDR's key people and played key roles even before being Solicitor General and Attorney General and then going on the court. But I think the reason is because he, especially in his time on the court, he really transcended partisanship, and he issued maybe his most famous ruling, the opinion he wrote in the Youngstown Steel case, was telling a Democratic president, Harry Truman, that he had exceeded the authority that the Constitution gives to a president. And ostensibly at a time of war. And showing that kind of independence and that kind of integrity, I think, was an important part of why Robert Jackson is revered by Republicans and Democrats alike. In addition, I think it has something to do with his mastery of the craft. He was such an extraordinarily eloquent and incisive writer. And he had also an integrity about him and the way in which he decided cases and the way in which he explained his decisions, which I think transcends partisanship.
Graduate of Yale College, Columbia Law School, law clerk to Judge J. Skelly Wright, and then you become a law clerk to William Brennan. Talk about Justice Brennan. This is the 84-85 term,
yep,
right?
84-85 term. Great justice. Even greater human being. You know, a lot of people who are great and are seen as great by the public, once you see them up close, maybe they're not as great as they seem from a distance. But Justice Brennan was the opposite. He was a wonderful, wonderful person, and it was a blessing and a joy to get to work with him every day. The way in which we worked was amazing, too. He, unlike most law clerks, when you're preparing a justice or a judge to get ready for a case, you have to write a lengthy bench memo. With Justice Brennan, we didn't have to do that. We just met every morning with him for 2.5 hours, and we sat around his desk, all four law clerks and him, and we talked through the cases. And it was just an incredible experience. I learned an enormous amount about the law and about integrity, and about really how to be inspired by our Constitution, because that was one of the things I think was a hallmark of Justice Brennan, is that he found inspiration in the Constitution. He found it to be a document that expressed our highest ideals and showed us what we needed to aim to try to achieve.
After there's the oral arguments, then the judges gather the famous 9 men around a table, they make the decisions. Were you then called into chambers to sort of give where the judge would give you the results?
So there was a woman there by the time I was there, Senator Day O'Connor. So there were 9 people around the table. And yes, what Justice Brennan would do is come in. Conferences were twice a week on argument weeks. There'd be a conference on Wednesday afternoon where the justices would vote on the cases they heard argument on Monday. And then there'd be a conference Friday morning where the justices would vote on the cases they heard argument on Tuesday and Wednesday. And then Justice Brennan would very faithfully, after each of the conferences, come back, and he kept very careful notes of the conferences, notes about what each justice had said. And he'd come back and he'd lay it all out for us. He would tell us this justice said this and this justice said that, and here's how it came out and here's why. And often as not, it was, so get ready to dissent. So.
Justice Brennan's career overlapped with Chief Justice Warren, Chief Justice Berger, and Rehnquist.
That's correct.
Did he ever reflect on sort of the leadership?
Oh yeah, he did. He revered Chief Justice Warren, and that was because the two of them were in sync in so many ways. And Justice Brennan, I think history now shows, and it's fair to say, was the architect of many of the most important of the Warren Court opinions, even ones that Justice Brennan didn't write himself. Chief Justice Berger, not so much. That was not a good relationship between the two. He was circumspect about it, but you could tell that he found Chief Justice Berger's leadership of the court to be frustrating. And I think at this point it's pretty much common knowledge among historians that that was not a great relationship. And what was really interesting to me was Chief Justice Rehnquist. Now, when I was serving as a law clerk, it was Justice Rehnquist. He hadn't yet been elevated to chief to replace Warren Berger. But it was shortly after my time that he was. And Justice Brennan loved Justice Rehnquist as Chief Justice. And the reason was because he felt that Chief Justice Rehnquist ran a fair court, a fair conference, that meeting of the 9 that you described, that he acted with integrity, that he ran a tight ship, that he respected all of his colleagues. And you would never hear anything but the highest praise from Justice Brennan for Chief Justice Rehnquist.
He was 1985. This has been during your time period. He gave a speech at Georgetown where he criticized Ed Meese for the original intent of jurisdiction, as described it as the arrogance cloaked as humility. Did he talk much about that whole original intent? And
I know about that speech, and that was written while I was there. And it was important to him both because you had Ed Meese's speech, and everybody, I think, in the public understood Justice Brennan's speech at Georgetown in 1985's response to the speech Attorney General Meese had given, in which Attorney General Meese had said that originalism was the only valid way to interpret the Constitution. But there was also another event that it was less notable, but I think also was a motivation for the speech by Justice Brennan, which was earlier in that year. William Bennett, who was then the Secretary of Education, gave a speech or made remarks in response to an adverse decision from the administration's perspective in the Supreme Court about I think it was a decision that restricted in some way the role of religion in public schools. And basically what Bennett's speech did, as I'm remembering it now, was to suggest that the administration ought to just go ahead and disobey the Supreme Court's ruling. And so a lot of the motivation actually was that too, that it's the job of the Supreme Court to say what the law is. This way of thinking about what the Constitution means is a totally legitimate way of thinking about it. It has a long and distinguished history. In fact, most of our country's history, the philosophy that he espoused has been the governing one, and somebody needed to stand up and say it.
Speaking of saying it, your career as a private practitioner, as an advocate for the Supreme Court, argued more than 50 cases before the Supreme Court, but there was always the first.
Yeah.
Do you remember that?
Yeah, I do very well. It was a case called MCI versus AT&T. You probably read it in your administrative law class or your statutory interpretation class. Was about the meaning of a particular word in the Federal Communications Act. And it was about the meaning of the word modify, and the statute said the FCC shall have the power to modify a particular requirement, and the FCC modified it by eliminating it, and it was a requirement that the client I represented at the time, MCI, wanted to keep in place, and so it was my job to explain that the word modify could mean eliminate in some circumstances. And in order to justify that, I cast around and looked at a bunch of dictionaries at the meaning of the word modify, and most of them had very unhelpful definitions, but there was one, happened to be the dictionary on my secretary's desk, that had a very helpful definition of the word modify. It said to make a major change in as well as a minor change in. So I put that dictionary front and center in our brief and said, see, you can read the word modify to make a major change. This is a major change. All good. You should uphold what the FCC has done. Turns out, unbeknownst to me, that dictionary on my secretary's desk had the reputation of being the worst dictionary published in the last 100 years. It's universally reviled by people who are experts in doing dictionaries. And it just happened to be the one my secretary had, and happened to be the one we rested our case on. And so you'll see this. And Justice Scalia wrote the opinion for the court rejecting the argument we were making. He talks all about how our dictionary was the worst dictionary ever written, and therefore the meaning that we found there was not worth it. So yes, I remember it very well.
Tell me about you just can't walk in front of the 9 justices and not have your gut turn over a couple times. What was your chemical reaction doing the first one?
Oh, it's been the same all 50 times, and it's the same every time I stand up in any court, actually. I'm always very tense in the run-up to an argument. And in fact, you'd think maybe it's the 47th, the 48th, the 49th, the 50th time in front of the Supreme Court that you'd feel really comfortable and you wouldn't be anxious in advance. But what I found for me is that the more I do it, the worse it gets. And the reason I think, it's a little bit hard to analyze yourself about these things, but the reason I think is because each time the bar gets a little higher, each time you've done it and you feel like you've done it well, you feel like, well, I could do it better. And so the pressure never really goes away. And I think that's probably a good thing. One of the career deputies in the SG's office, Ed Needler, is a remarkable guy. He's just celebrated his 40th anniversary in the SG's office earlier this year. And he's approaching 150 arguments in the Supreme Court. And yet, you would think if anybody wasn't going to be nervous, it would be Ed. But when Ed stands up from the counsel table to go to the podium and he's got papers in his hands are shaking. And so that just tells you, I just think that's the way it is. And I think it actually helps you do better. And it's painful to go through, but it helps you do better.
As you worked yourself into the Obama administration, well, let me back up. You were in private practice and they reached out and grabbed you. Is that an aspiration? Did you want to get into government, or was
it's more like I jumped in. I had settled in Washington, always hoping to work in the government, and then I woke up in my 50s and I hadn't. And I had been a supporter of President Obama when he ran for president. I found him to be very inspiring and wanted very much to be part of his administration. And the opportunity came along to work as an associate deputy attorney general, work in the deputy attorney general's office, and I just jumped in. It was my one chance to do it, and I was going to do it, and I did. And I'm really, really glad I did. Probably the best professional decision I ever made.
There's a book just came out last year called Advising the President. It's authored by William Casto. It's dealing with Franklin Roosevelt's time period with Robert H. Jackson with Franklin Roosevelt. You were deputy White House counsel. What is the role of White House counsel?
Well, it's a very complicated role. In fact, you wear several different hats when you're the White House counsel. You work in the White House counsel's office. One thing you do, and you're seeing a lot of this with the current administration, is you represent the interest of the presidency. You're not the president's personal lawyer ever in that role, but you represent the interests of the presidency, and you assert those interests against Congress and against the courts to try to protect the prerogatives of the presidency. And you really do have an obligation when you have that job to think not only about your own presidency, the one you're serving in, but the future presidencies and preserving the authority of presidents in the future. So that's a big part of the job. You're also involved in this running the process that suggests to the president who should be nominated to the federal judiciary. And then you're also involved in a lot of different aspects of policy. For example, one of my jobs as deputy counsel to the president was to be the counsel to the National Economic Council, which is an office in the White House that helps shape economic policy, and legal issues come up there, and one of my jobs was to be a counselor to them. So it's a counseling role in every one of its aspects. You don't actually litigate when you're in that office, but it's counseling across a whole range of really important functions.
How much does real politics enter your job description?
In the White House counsel's office? Mm-hmm. So again, hard question to answer. Like always, but in some ways never. In that you're always dealing in a political context, and you're always dealing with political forces and political pressures. But a big part of your job is to focus on what the limits are. Your job as a lawyer is to say, we can go this far, but we can't go any farther than this. We can do it this way, but we can't do it that way. And standing up against the political pressures from people who aren't lawyers and don't always understand the niceties of the law is a very important part of the job. So it's almost always in a political context, but you're not making partisan judgments. You're making judgments about the law, just like you would in any other setting as a lawyer.
You then become Solicitor General. Who preceded you? What was the sequence?
So Elena Kagan was the Solicitor General before me, and then she was nominated to the court and confirmed by the Senate, took her job on the seat on the court, and then there was an acting Solicitor General for a period of time, Neil Katyal. I was nominated by the President in January of 2011, confirmed in June of 2011. And I felt like it was a really partisan process getting confirmed by the Senate, but as I look back on it now, I realize compared to where we are now, it was a cakewalk. I had a contentious hearing, but one that ultimately ended up with all but one of the senators on the Judiciary Committee voting for me, and then some 70 plus votes on the floor of the Senate. And they didn't even invoke cloture, so they didn't even have to have a vote about whether they were going to filibuster. They just put me on the floor and they voted, and boom. So it was painful, but actually, in the great scheme of things, it was pretty simple deal.
You're known for many things, but one certainly arguing the Marriage Equality Act. One of the petitioners was a married individual named Campion, who was from Jamestown, New York.
Is that right?
Yeah.
I didn't know that. I didn't know that.
We had an event shortly after your argument at the Jackson Center, but before the decision, where he and his partner came here and we interviewed them about that. Was that a difficult case for you? It's now in hindsight, it seems like.
So that issue had a long history for me as SG that started long before 2015 when the Obergefell case was argued and decided. Rewind a couple of years earlier, there were two cases in front of the court at the same time. Windsor against the United States, which was about the unconstitutionality of the Defense of Marriage Act, and Hollingsworth against Perry, which was about California's Prop 8 and which forbade marriage between same-sex couples and whether that was a violation of the Constitution. So we had to really get engaged in that issue back then. The United States, the Department of Justice had done a very unusual thing in the Windsor case in saying that instead of defending the constitutionality of the federal statute, the Attorney General and the President together decided that they believed that the statute could not be defended, that it violated fundamental constitutional rights and constituted discrimination based on a protected characteristic under the Equal Protection Clause. And so they ordered the Department of Justice not to defend it. But that all happened before I became SG, but I was carrying that out as SG. And then the court granted the Hollingsworth against Perry case, which directly asked the question as to whether the 14th Amendment protected a right to marriage equality, and we had to decide what to do as the United States. If we went into the marriage equality case, Hollingsworth, and took the position that the 14th Amendment and our understanding of it did require marriage equality and therefore required the invalidation of Prop 8, our concern was that the key vote in the case, Justice Kennedy, was going to think this was too far, too fast, and that if ruling in the way the United States wanted him to rule in the DOMA case by striking down the Defense of Marriage Act necessarily meant he was going to have to rule for marriage equality in Hollingsworth against Perry, that he might not take the first step because he didn't want to take the second step. It was a really hard case. We ultimately decided that the right thing to do was to step in and file a brief in the Hollingsworth against Perry case. For one thing, the position we were taking in the DOMA case about heightened scrutiny under the Equal Protection Clause applied in the Hollingsworth against Perry case, and it would be very odd for us not to have said anything about it. And they were certainly going to ask me, the cases were argued, Hollingsworth against Perry on a Tuesday and Windsor on a Wednesday. They were definitely going to ask me Wednesday what I thought about the case Tuesday, even if we hadn't filed a brief. And so we thought the right thing to do was file a brief. We had to get the president to make that decision. That was the one time in my career when I actually went to the president and asked what we should do. And the reason was because the president previously had taken the position that it ought to be up to the states to decide the issue of marriage equality. And for us to file the brief we were going to file, he would have to change position. And that was above my pay grade, changing the president's position on something. And so we went and met with him and had an extraordinary meeting, which I won't give you the details of because it would take an hour here to tell you about, but it was amazing. And the president decided that we were going to file that brief, and we did. And I did the oral argument, as I said, oral argument on Tuesday in Hollingsworth and Wednesday in Windsor. And I will say, the oral argument I did in Hollingsworth against Perry went over like a lead balloon. And it just didn't go very well. And a big part of the reason why, I think, was that I was giving a very sort of doctrinal lawyer kind of an argument, saying, look, the Equal Protection Doctrine says heightened scrutiny applies when the following conditions exist. These conditions exist, 1, 2, 3, 4. But you know, the issue at the end of the day transcended legal doctrine. It was about something much bigger for the country than that. And arguing about legal doctrine, it just didn't work. I just wasn't talking about what really mattered at that moment. And so one of those rare things, I got the chance to argue it again 2 years later when the court granted cert in the cases, including Obergefell. And so when I went back the second time, 2 years later, I decided that I was just going to argue it in a fundamentally different way. I was going to argue it as, I was going to talk about what really mattered. And what really mattered at that time, I thought, was, is this a question that should be answered by the courts, or is this a question that should be answered by the majoritarian branches of government? And two, if it's going to be the courts, is it a question that should be answered now, or is it too soon and courts should wait? And so I really structured all of the arguments that I made in that case of oral argument around those two questions, which I thought really were, at the end of the day, that's what you really had to wrestle with if you were going to decide this case. And the answers I gave really actually came out of that conversation I'd had 2 years earlier with President Obama. Those were the things that we talked about when we had that meeting. And I drew on the answers that we kind of were batting back and forth 2 years earlier, and just said, well, I said at some level, I'm going to have the same conversation with the Supreme Court that I had with President Obama 2 years earlier, because we were talking about the things that really matter here. So that's what I did. So that's a really long way of saying, no, it actually wasn't that hard to argue the case the second time, because I'd been through that experience. I'd really had a chance to think about what mattered here, what needed to be said, and I went in and said it.
So after the decision was announced, did you ever be with the president and at least virtually kind of high five based on his decision?
So I got a phone call from him, I think. No, I didn't actually. I didn't on that one, because that, you know, I had this period of time, and don't get me wrong, I was just really lucky to have it. But I had this period of time in June of 2015 where on, I think it was a Thursday, anyway, one day of the week, I got a ruling in two cases I had argued. First one, King against Burwell, which was the second case that upheld the Affordable Care Act, and then a case called Texas Inclusive Communities, which was a case about whether you could have a disparate impact theory of liability under the Fair Housing Act. And in the second case in particular, nobody thought that the government's position that you could have disparate impact had a chance in the world of winning. And we won both of them on the same day. And I got a call from the president that day as I was coming back from the court, and he called me and he said, hey, Don, I'm on the cell phone, you know, and I'm walking into the building, and he says, hey, Don, I just want to congratulate you. I don't know how you won that Fair Housing Act case. And he didn't say a word about the Affordable Care Act case. But then he came back around and said, and the other one too. Anyway, but then Obergefell came out the next day. So, he wasn't going to call me again. And in truth, he shouldn't have, because that wasn't my victory. That I played a very small role in that, but that victory occurred because of decades of work, really, by people who cared very deeply about that issue and devoted their lives to it, and it was their victory. So, he called them, he called those lawyers, he didn't call me, and that was the right judgment, because that was their victory.
You mentioned the Affordable Care Act, and probably there's probably no more issue before the court which had attention drawn to it.
That's one way to put it, yeah.
To it. And I think Jeff Toobin wrote even an article talking about the heavy burden that you had. I mean, just and the case. Again, for the students who probably read about it, but kind of draw us through a little bit of that, because it was high drama. It
was amazing, yeah. I mean, here you have a statute that was the most important accomplishment of President Obama's first term. I mean, you can argue maybe that pulling the country out of the slide towards depression was the most important accomplishment, but in terms of policies and laws for the future, this was the most important piece of social legislation since Medicare and Medicaid, almost half century earlier. And we had to defend it. And I'd been very involved in the defense of it right from the beginning, even when I was in the White House before coming over. And came over, went to the Supreme Court, and there was, it was not lost on anybody that this was an incredible historic moment, and that a huge amount was on the line, because by the time the case was argued in June of 2012, it was an election year. And so you had before the Supreme Court the constitutionality of the president's singular accomplishment in office, most important accomplishment in office in terms of legislation, a few months before an election. And the pressure was pretty intense. And and I will say, although most academics, most academics on the left at least, thought it was a pretty straightforward case, the statute was obviously constitutional, we were always worried that it could be a tough sell to a court that was composed of a majority of conservative justices, because you could think about the position here as being of Congress requiring people to purchase insurance as being a step beyond anything Congress had ever done. Congress regulates the economy all the time, and it has that power under the Commerce Clause, and that's very well established. And of course, Justice Jackson's opinion in Wickard against Filburn is the key precedent, historic precedent, establishing the scope of that power. But there was an argument that the Affordable Care Act went a step even beyond Wickard against Filburn, because instead of ordering people not to do something, it was ordering people to take a step in the economy that they might not otherwise take. And so we were under no illusions that it was going to be an easy sell to the conservative majority in the court, which is part of the reason why we thought the tax power as an alternative basis for upholding the statute was so important, because that was a narrower power. It was a power that Congress had to tax and to impose conditions on taxing and avoiding tax, but not one that allowed Congress to do anything more. The commerce power that Congress can use to enact laws of any kind, laws that prohibit things, they make things crimes even if they want. There are all sorts of ways in which the government can bring coercive force to bear into the commerce power, and they can't do those things with the tax power. All it can do is impose a tax. And so we thought it had a real chance to be a more appealing, narrow basis to uphold the decision. And so we actually spent a lot of time as the case progressed from the Courts of Appeals into the Supreme Court, trying to develop and deepen that argument and make it a stronger part of our presentation, and in particular to make it, to get the court to focus on the point that, which I think was really important, that there's no doubt that Congress would have had the power to do exactly what the Affordable Care Act did under the tax clause, on the taxing power of the Constitution. If the statute had simply said the word tax in the place of where it said penalty, so where the statute says you shall pay a penalty of X if you don't have insurance, but it said you shall pay a tax of X, 100% certain that it was constitutional. And so, and it was, after all, in the Internal Revenue Code, and you paid it on April 15th, and boy, it looked like a tax in every other way except that the word penalty was in there instead of tax. So the pitch to the court was really, hey, you're going to strike down this landmark piece of social legislation. You're going to bring this whole thing crashing down, even though Congress does have the power to do exactly what it did, because it has one word in there, penalty instead of tax. You're really going to do that? We thought that actually it was going to be very, very hard for the court to reach the judgment that it would bring this thing crashing down, even though it was something that Congress could do based on that one word. So we pumped that up as hard as we could. And then we got to our argument, of course, and it was really rough. There was a huge amount of hostility. It was not my best argument, that's for sure. But, we did at the argument, it was argued over 3 days, and I argued in each of the 3 days. And the argument about the mandate was on the second day. And we did manage, I managed, it was an hour per side, which is unusual. Normally it's 30 minutes per side. I managed to kind of fight my way through all of it. In the last 10 or 15 minutes, I talked about the tax power. And, in retrospect, I feel pretty good about that, because if you look at the court's opinion, basically, and you look at the last 10 minutes of the argument, it's all right there. But the thing I actually, I think back on my time as SG, and I felt really great about the oral argument of Bergefell. The other thing I felt really great about was actually the ending of the oral argument in this case, in NFIB, because at the end of 3 days, third day was about the Medicaid expansion. At the end of the 3 days, I said, I just want to take a minute and sum up something like that. And what I talked about at the end there was that the other side was challenging the Affordable Care Act on the ground that it was an infringement of liberty, but that was really a misunderstanding of liberty, and that what the Constitution did was give the government the power to secure the blessings of liberty. That's in the preamble of the Constitution, and that's what this law did by giving people the ability to live healthy lives, and therefore enjoy the blessings of liberty because they had their health. And when I think back on all the things I said standing at the podium, that's the one I feel best about, even though it occurred in this otherwise very difficult context.
The decision comes out, the world is holding its breath, wondering how it's going to fall, and Chief Justice Roberts grabs that 10-minute moment and talks about the tax. Did you see? Did you suspect that would be a game changer?
Yeah, I thought, as I said this a minute ago, I thought that there was a really good chance that's how we were going to win the case. That's why we pushed it so hard in the briefing. That's why we pushed it so hard at oral argument. You see, if you go back and listen to it, you'll see, I'm trying to fight my way out of the tax power discussion, out of the commerce power discussion in the last, when I'm at about the 15-minute mark left in the argument. I want to talk about tax now, and they'd ask me another question about commerce. And I'd say, I want to talk about tax now, and they'd ask me another question about commerce. If I'm remembering correctly, I think it was Justice Sotomayor who finally said, okay, please talk about tax. And I got to, do my thing. But that was because we thought that it was a pretty good chance that was going to be the basis for the decision. And really, the whole experience of being there, when you're SG, you go and you sit at counsel table when the court issues its opinions and reads out the results. So I'm sitting there at counsel table, and man, was that a wild roller coaster of a ride listening to the Chief Justice deliver that opinion, because he starts by saying, here's the issue, and he goes through the whole Commerce Clause analysis, and he says, and guess what? This is not valid under the Commerce Power, so we're down here. And then he says, then he said the word but, and I went, oh, he's going to rule for us on the tax power. And whoosh, way up here again, he upheld the thing on the tax power. And then he got to Medicaid, and he said, well, this violates the coercion principle of the spending clause. I'm down here. And he said, but you can interpret the statute in a way so that states can opt in. So I was back up here again. It was unbelievable 15 minutes going through that.
Wow. So you go home that night. What did you say to your wife?
I don't remember. I was basically numb. I think we left that day, the next day, maybe on a vacation up to a lake up in New Hampshire, which was perfect, just get completely away from everything and get in a canoe and paddle around on the lake. But I was numb. It was so intense. I mean, it was an amazing thing. It was an amazing thing.
Well, congratulations. And just to kind of bring everything current, I know as we were scheduling you to be the 15th annual speaker at the Jackson Center, we knew that you potentially could be arguing this again. Judge Reed O'Connor ruled in December that a congressional tax law passed in 2017 zeroed out the penalty imposed by the ACA's individual mandate, rendered the entire health law unconstitutional. Then now it's before the Fifth Circuit.
So yeah, it's like, you know, you all know that old horror movie series, Halloween. And it's like, he's back. Well, they're back, you know, third try. And so I'm representing the House of Representatives, working with the House Counsel and others to represent them to defend the law, because of course the Department of Justice has decided that they're not going to defend the law. So we've stepped in along with a group of states who are defending the law, and you know, stay tuned. We're not done with that either.
Wow. As you're tying up a lot of your time, we'll let you go in just a second. You're going to speak today, and I don't want you to give the speech, but is there a theme, a walk away, which these students are going to...
Yeah, I hope so. I hope so. I'm going to start with Justice Jackson's dissent in Korematsu, and try to distill out of that something that I think is a really important general principle, not really a legal doctrine, but the question of, you know, what should the Supreme Court do when it's faced with an action by the other branches of government, by the president, essentially, that it believes isn't on the level. What should it do? And that you saw the Supreme Court struggling with that in the travel ban case, Trump against Hawaii, and ultimately upholding what the president did. And then even though there were serious doubts that the government's action was on the level. And then you saw again in the census case, decided just a few days ago, same dynamic, that there you had the Supreme Court grappling with justification for including the citizenship question on the census form, and having a pretty strong sense that the arguments that the government was presenting in defense of doing that just weren't on the level. And actually in that case, following what I take to be the key wisdom of Justice Jackson's dissent in Korematsu, and acting with integrity and saying, look, whatever else is true, when the government comes to the court, it better be acting on the level, and it shouldn't expect to see its actions upheld if it isn't. And so that's what I'm going to be talking about today.
You're terrific. Thank you so much.
My pleasure.
This is fantastic.
Thank
Great.
you.
Thank you.